RERA, or the Real Estate Regulatory Act, is meant to protect the interests of the home buyers and ensure they do not get stuck in unfinished projects. The implementation of RERA by several state authorities has come under scrutiny many times over. But an act or any law of the land is evolving in nature, and today on the Property Show, we not only look at hits and misses of RERA for homebuyer protection, more importantly, we bring forth a few important court rulings which have strengthened homebuyers' protection and taken away ambiguity in the interpretation of the law. So stay tuned, because an understanding of your rights under RERA is as important as buying a home. My guest on the panel today, Varun K Chopra, Advocate, Supreme Court of India. We also have with us Amit Kumar Kedia, a Chartered Accountant and RERA Specialist, and Ishan Singh, an aggrieved unit holder who has first-hand experience of dealing with RERA for several years now and has been tracking other important RERA cases. Varun, let's start with the most important hearing at the Supreme Court, which was presided by the CJI to be DY Chandrachud. The dilution of the model builder and buyer agreement, which he has now asked the centre to relook at and make sure that there are no gaps in that. Do you think that is one of the most significant hearings that we should be looking at for homebuyer protection?
See, firstly, thank you so much. And like you rightly said, yes, the CJI2B is very, very keen in this current issue, which has been raised in a writ petition, which has been filed under Article 32. And the primary issue which the court is looking at, the matter was lastly taken up on the 4th of October. Now it's likely to be taken up on the 28th of November. The issue is with regards to a model builder buyers agreement. And what is the reason of bringing this about? Because as per the CJI2B, it is a very serious issue which the centre should look into. It's going to bring in the accountability of RERA and accountability between the players. There has to be fair play, and it will bring in a lot of transparency in the matter with regards to these builders and the propositions which they make. In fact, if we should not go that far, in recent times, there have been certain huge builders, those who have been looked up upon by the Competition Commission also by saying that their agreements are completely in violation of Section 4. So keeping all those aspects in mind, the CJI2B also has invested a lot of time in this and is proposing that those agreements should be placed by the central government, and they can actually facilitate and help the RERA also to develop its more accountability in the present.
Right. Okay, Amit, so what we are hearing is, and this is something which has been submitted by Ministry of Housing and Urban Affairs, that they are now looking at breaking the builder-buyer agreement or the model agreement into two parts. Some clauses which the states cannot absolutely change, but another set of B clauses which can be modified looking at a particular region or state's complicities, I would say, or complexities rather would be a better word. Do you think that that still leaves room for the builder-buyer agreement to be actually, modified by states? Why break it up into two parts? Why not just follow the model builder-buyer agreement set up by MoHUA?
Thank you. First of all, I would thank NDTV for calling up and giving this opportunity. Replying to your question, basically, as we know very well, land issues are related to the state subject. So, being and due to which this is a reason why, it has been proposed that it could be made in two parts. Because at times it do happens, there are different set of rules, regulations, which are to be followed as per the state, as the state legislation is having the embed of the land issues.
So, Amit, you believe it's not right to break it up into part A and part B?
Yeah, so there where I am coming, breaking up part A, part B should be there, but to the extent that it is linked to the land issues at a local level. More than that, there are several things which should not be breaked into. For example, if a particular decision have to be taken, like the ambit of RERA, or which projects should fall in RERA, which should not fall. It is not a local state subject. that should be very well stuck.
I'm
So,
sure with I'm sure with that much of attention of CGI to be, they will not dilute those aspects at all. Let me come to Ishan. Amit, I'll come back to you. Ishan, very quickly. So one is, of course, the model builder buyer agreement, and we are all hoping that MoHUA will submit a serious and strong plan after taking all the inputs from states. They're still awaiting few states to give their inputs. But do you think that alone will be effective in making RERA effective?
Actually, hi. Thank you for having me on the show again. It's always a pleasure. Just to take up on what I think the point that Amit was trying to make, let me expand on that. Since land is a state subject, the licensing of a project, the process by which a project is licensed, is determined by rules of that state. Let me give you a very quick example. So if you have a project in Noida, for example, you get the project licensing and permissions and everything from Noida authority. If you're in the state of Haryana, you go to the Director of Town and Country Planning. Now, the rule for getting the land and converted project is very different. In Noida, you can't buy land from farmers, then go to conversion. You get land with entitlements from the authority. In Haryana, you buy the land from the farmer, then you go to the DTCP, which is the Director of Town and Country Planning, who then gives you the license for the land. Now, the reason you can't have one standard model conduct is because there is already, RERA came into play in 2016, but there were already legacy institutions which were dealing with the regulation of the project and licensing the project and compliance of licenses. So one of the things which I think needs to be addressed before we jump into having model buyer role of conduct is of the model buyer agreement is the role of the legacy institution which is giving the license and the regulator RERA, which is then in a way policing the license. Because you have two disjointed institutions which are following different laws. So if I had to say one thing to DYC, the Chief Justice of the Parliament today was, please step back a little bit. You've done a great job with RERA, but every state has different sets of rules which have to be captured, say, in part 1 of the builder-buy agreement. For example, Haryana, the builder-buy agreement is based on the power of attorney a landowner gives a developer. Now, RERA will hold the landowner to also be a promoter. Now, how is the landowner a promoter? So there are a large number of issues that come up with
All
this.
right. So I think the panel is, Ishan, the panel is in agreement that dividing a model builder-buyer agreement into two parts is probably a better way forward than having one and then expecting it to be implemented across states which do have very, very different land acquisition laws and rules. Varun, I'm going to come to you. So let's wait. Let's wait for that November hearing day when MoHUA will submit a new plan on builder-buyer agreement and how to implement it. Let's just move on because we've got a lot of ground to cover. What are some of the other critical judgments which you've seen in the last few years which have actually strengthened home buyers' rights?
See, specifically speaking, one of the matters which actually dwelled into the regulations and dwelled into the delegation of powers and the principle and the jurisdiction of RERA was the new tech promoters, which was decided by the sitting Chief Justice of India, which actually defined the powers of the adjudicating officer, the regulatory officer, etc. In fact, the most important part of that judgment of new tech, in fact, I happened to appear in that matter as well. I had the opportunity to argue that also. The most important aspect of that judgment was that it is not, RERA will not be applicable when there is 8 units, etc. There is a specific section 3.2 which specifies anything which is beyond 500 square meters, you have to register. So that principle has to be followed, which in my opinion has come out beautifully in that judgment. And of course, it is going to help the home buyers.
Varun, you've actually opened the Pandora's box, or let's say the real estate box of Delhi, because that's literally not covered, wasn't covered before Delhi RERA came out with that clarification as well, and then to support the new tech case that, you know, it does not matter whether you are building 8 units or not. If you're building on anything which is over 500 square
500
meters,
square meters.
it has to be RERA registered. Amit, take on from
That's
where...
the law. In fact, just sorry to intervene. That's the law. That's 3(2). It's clear. It's very, very clear in this law. Every law has to be read in its letter and spirit. So that's what the Supreme Court also has done. Sorry to intervene.
All right.
So
Amit, take on from here, and there are other ways in which can you take to RERA authority as a home buyer? What do you need to take to the educating officer? That also has been made very clear in the New Tech case. Can you give us a flavor of that?
Yeah. So from beginning, it was either or, that either 500 or 8 if anything breaches. Then, but with this New Tech, it had been clarified that if anything breaches either 500 or 8 units, then the project need to be registered. In addition, the adjudicating officer, where the complaints were filed by the allottees for even the refunds and for the interest, all was getting messed up. And with this order, a clarification came, like now only the compensation would be taken care by the adjudicating officer. Rest all matters need to be taken by the RERA authorities, and so further whatever decisions come from these authorities would be taken to the tribunal. That was a very big breakthrough, where majority of the allottees are doing mistakes as on date. So this would be rectified. In addition, the New Tech judgment have also given the clarification for the single member branch, and like they have safeguarded the deposit of the fund at the time the case and the matter goes to the tribunal, wherein the home buyer would going to be secured if there is an appeal from the developer side, wherein the amount of the principal amount which need to be given, or if in case of the interest or compensation need to be given, at least 30% and to the tune of 100% amount is to be deposited to the tribunal. With this, what would going to happen is there would be a reduction in the forgery and the issues which are held by the allottee.
Okay.
Because the developer need to now, if they do any mistake or if they do any undue fault with the allottees, they have to, and they loses, then they need to deposit the 100% amount to the authority.
All right.
So,
okay.
With these clarification with the New Tech judgment, it have given a new benchmark to the RERA itself.
Okay, so to all our viewers, the New Tech judgment is an important one that you have to see. But I'm going to just come to Ishan on another one, because Ishan has been looking at different forums for justice in his case. So, RERA versus Consumer Court versus IBC. There was a lot of confusion, Ishan. If I go to RERA, I cannot go to Consumer Court and I cannot trigger IBC. But that is now all clear. You can be on multiple forums now.
Well, you can be on multiple forums, except if you're in RERA, you cannot be in a high court asking for an appeal. So it just happened in a case where I was present. So you must understand, the unit holders and individual is up against a very powerful builder lobby. Now, the proviso is that if you are in RERA asking for a refund, you can go to NCLT, you can go to a consumer forum. But if you are part of a writ petition, you cannot be asking for the relief of refund or interest in the writ petition. So in a case where I was there, perhaps the allottees were misinformed, but the builder's lawyer took their objection and substantive arguments. It wasted about a year of arguments and dates in this small technical matter.
Varun, that's yes. A bit of a bummer when it comes to home buyers, isn't it? It sets them back.
See, we have to understand, there are various forums in which a home buyer, by the end of it, why does a home buyer approach so many forums? It's because it's their hard-earned money and they want a relief as soon as possible. So they may approach as an allottee. IBC got an amendment that they are allottees. They part as a financial creditor, they can approach the IBC, which is the Insolvency Bankruptcy Code 2016. Then there is the Consumer Protection Act. keeping these in mind, a person can go to the Consumer Protection Act. Of course, I can file a complaint in that. And this was duly clarified by a judgment, which is Aftab Singh, which is of the Supreme Court, which clarified that a consumer protection complaint would have nothing to do with a RERA complaint for that matter. I can definitely approach them. Now, with regard to the IBC aspect also, see, we have to understand a consumer or an allottee for that matter is going to IBC for a different purpose. Under the Consumer Protection Act, the allottee or the home buyer is going for a different purpose. It could be for refund, it could be for compensation, etc. But in an IBC, what does a consumer or an allottee go for? It is seeking an insolvency because the buyer is not able to repay them back. But what is the outcome of it? They get into moratorium and it completely closes their revenues. But still, they can approach that. Now, the last aspect is with regards to the SARFAESI. Now, the SARFAESI aspect also, banks brought up a huge argument with regard to SARFAESI. But that is also been clarified by the Supreme Court by Justice M.R. Shah, who clearly says that the allottees and home buyers have a precedent over the banks as well. So for that matter, they have various rights which is there. And of course, it has to be played in a manner that it secures their rights, not dilute them.
And sometimes having too many forums and different buyers approaching different forums isn't a good one. The purpose for actually clarifying what rights are available to home buyers is that depending on your case, take legal advice and then approach the right forum for your grievance redressal. We're going to come back now and take a quick look.
I completely agree with you on that point. Completely agree with you.
There's a very critical point here which is missing, Manisha, just for the educational consumers here.
I'm going to come back. I have to take a break, gentlemen, but let's discuss that when we come back on what to keep in mind when you do want some grievances redressed as a home buyer. Stay with us. A much needed spotlight on the hits and misses of RERA, or the Real Estate Regulation and Development Act 2016, to see how effective this act has been in empowering the home buyers and cleaning up the sector, especially with subsequent rulings of different courts. Ishan Singh, you had a point on the fact that, maybe forum shopping isn't the best way for aggrieved home buyers to get justice. But coming back to RERA per se, you've been fighting several cases in RERA. What has been your experience? What are actually the big gaps? Do you get justice or you don't?
So, Manisha, no, I think there is a long way to go with RERA. Cases, the ones I've been concerned with, have been in court since 2018, 4 years now. There's been no justice. There are inconsistencies like clause 88 to 89 of RERA. But I hope the government will review it and make something good better.
Varun, I'm looking at, you're hearing a lot more positive, at least, outcomes. There was a RERA order which said that, Skies Project Sector 37C, Ramprus developers have to refund the entire amount to home buyers because they've not given possession. Then you also had RERA issuing warrants against the directors of CHD developers for their failure to refund the paid up amount which RERA had ordered. So I feel that there is a lot more pressure, I think, on RERAs to perform and deliver for home buyer protection. Would you agree with that, or you think we still have a long way to go?
I completely agree with it. I will tell you why. See, RERA was a legislation which was made for basically accountability towards the allottees and have a transparent system for a fair and free play. And for that only, RERA was established as a regulatory authority to fast track all of it. Now, if a home buyer, for that matter, seeks a lot of advice from a lot of lawyers, and I always, as a lawyer, always say, too many cooks spoil the broth. If you have too many lawyers advising you on a particular issue, you may go to Consumer Forum, you may go to RERA, you may go to IBC. But then what happens? Your focus is derailed. So focus on RERA, which is a specialized body in order to protect the interest of home buyers and the allottees. And that will make you succeed. And like you rightly said, they have immense powers. In fact, the Supreme Court in recent times has been recognizing it and trying to develop that law to protect the interest of all the allottees and home buyers in this country. Right. And that's why it has been made a state subject also.
So you're saying stick with RERA first and try that as your first and best option before going to other forums. Amit, very quickly, of course, there are other cases we couldn't discuss today that, the clarity on the parking lot, which is a big issue in Mumbai, that if you're giving an allottee a flat, you have to give him the parking lot. You cannot sell the land to somebody else for some other use. But we won't go into the detail. Quick concluding remarks in terms of where RERA was in 2017 and where do you see it today in terms of protecting home buyers?
Yes, definitely. In these 5 years, it have evolved a lot, wherein the parking have been clarified now. No common area parking could be sold. Only the FSAI for which FSAI have taken could be sold. Apart from that, other clarifications from various authorities and the Supreme Court have came. The act is new. The issues which were old had to be segregated, and it is being done. It's just as told by the co-speakers and the panelists that it just needed to give some time and be very specific towards RERA, and definitely in time to come the resolutions would be there. But just doing a forum shopping would not going to help.
All right, Ishan, Amit and Varun, thank you very much. I mean, this time for a discussion like this always feels very, very short. But according to me, there's still some way to go for RERA, even though a lot of way has been covered. That's it from us at the moment. Thanks so much for watching.